Dear speakers and participants, we start the second day of our transnational training event during the Intellects project. Yesterday, Cristina Tamburro showed us the meaning of this Intellects project, and now we start the experiential second day of our meeting. Welcome to everybody. Let's start. I give immediately the word to Francesco Sacco, and please, Francesco, start your demonstration. Please, Francesco.
I don't know why. Okay, I'm here. So welcome to everybody. Let's start the second part of this dissemination workshop about the SCAN project and the demonstration about the NTERLEX project. I'm sorry. The NTERLEX project is a project focused on the international private law and about it's built about a platform to introduce this law and this private international law. So I don't know if you see me because okay, my monitor was blocked. Okay, I will leave the word to Risto that he will introduce the Intellects platform, and he will show you all the step by step the tools built in the Intellects.
Thank you very much, Francesco. It's indeed a pleasure for me to introduce you the Intellects platform. I have prepared a presentation, but most of the time, some slides, but most of the time I will show you the system live on internet. Let me share my screen. I just want to make sure that you can see my screen. Francesco, is it visible?
Yes.
Okay, thank you. It's indeed a pleasure for me to present you the Intellects platform, which was developed by all partners in this very interesting and exciting project. It's a platform that provides legal information, decision support, and online training on private international law. The tools that we have developed in this project are three. We call them modules of the platform. The first one is the decision support module. The second is a legal database called Find Law module. And the third module is a training module. What is important to know is that all these modules can be accessed free of charge. They are available on internet and more precisely on the Intellects portal. The link to this portal is already published on with the materials that you have about the today's workshop, and also I promise that after my presentation I will send my presentation so that all of you will have access to it. But again, the most important thing is that the platform is available online on this web address, which is interlex-portal.eu. I will even open it in my browser. On the portal, there is a brief presentation of each of the three modules and links to each of the modules, and of course some information about the projects, its results, the partners involved. I will start the presentation with the decision support module, which is an interactive expert tool that intends to guide you when you would like to determine jurisdiction and or applicable law in a specific case involving an international element. This is the home page of the module. Okay. At this home page, we provide first an introductory information about the module so that the users get information, can have information what is the tool about and what is its scope of application. And what is also very important, that we have put here a disclaimer. With this disclaimer, we would like to tell the users that the tool provides only decision support, but does not substitute the user in decision taking. This is not a decision provision module. This is decision support module. This is very important. The system does not substitute the user and the lawyer in his mission to provide legal advice. We have written in this disclaimer that okay, I'll open it. That the information in this module on the Intellects portal provides only is of general nature only, and does not constitute professional or legal advice. After that, in this front page, we have also described the scope of application of the module, which actually coincides with the scope of application of the Brussels 1A regulation concerning jurisdiction in civil and commercial matters, Rome 1 regulation concerning law applicable to contractual, and Rome 2 regulations, law applicable to non-contractual obligations. So the material scope actually of the module covers, coincides exactly with the territorial, material, and temporal scope of these regulations. How you can use this module? In the center of the screen, you see this button, tell us about your case. And now we see the interface of the decision support module. It consists of several sections or panels, if you like. The first panel is concerns is about communicating with the users through questions, and by receiving its answers, the system learns more about the facts related to user's case, and with the next button, after receiving some information, the system puts the next question, so that all the relevant information about user's case can be received by the system. You see that there are two navigation buttons, next, previous. So in this way, the communication with the user is performed in this panel on the left-hand side of the screen. On the right-hand side of the screen, you can see some comments written by an expert in private international law. Actually, this is the way how the system provides decision support, advice, but again, the decisions are taken by the user. For instance, in this screen now, the question is about the type of the contract, because in the previous screen, the user has chosen that the case concerns a contract. And now the question is about the type of the contract. And in the comment section, we can see some explanations about the concept, methods related to a contract, what encompasses this concept. And in the comments, there are links to relevant provisions of the regulations. In this case, the link is to Article 7, Paragraph 1 of Brussels 1A regulation. There are hints which allow the user to see the full text of the cited provision. But if the user will click on the link, then a new window will open, and actually the link is referring to the text of this article, but in the other module, which is the legal database module, the so-called find flow module, which I will show a little bit later. So this is the way how the modules are connected. Also, there are links to the relevant cases of the European Union's Court of Justice. Again, if the user clicks on the link, the full text of the decision is open in the legal database. All the references are shown in a separate panel, which you see below the panel with the questions to the user, the communication panel. And in this way, the interaction with the user is performed. Okay, I'll choose some answers. And you can see at the bottom of the screen, there is another panel which indicates the steps taken by the user, and the user can return back to each of these steps if needed. So this is the interface of the module. Let's see more precisely how the interaction is performed. The first question to the user is on which issue the user would like to be supported in connection with his case. Jurisdiction and applicable law, both, or only jurisdiction, which means which will be the which courts of EU member states, the court of which EU member state will have jurisdiction in user's case, or which will be the applicable law. I will choose the first option, jurisdiction and applicable law. On both issues, we would like to receive some support. In the next question is about the subject matter of the case. What is the case about? Contract, delict or quasi-delict, unjust enrichment, etc. You can see here that we have chosen a little bit another way of understanding the legal matters of the case. What is the case about? Not the way how the regulation, the logic of the regulation is structured, because our intention was to address the real case that the user has. So if in this case I will choose contract. And the next question is about the type of the contract, civil or commercial contract in general, which means that none of the other type of contracts listed below is involved. The other types are consumer contract, individual employment contract, insurance, etc. You know that for each of these types there are special rules of Brussels 1A regulation. And on the right hand side there is a comment about the matters related to contract, what this concept encompasses. Then the next question, I have chosen civil or commercial contract, is whether the contract in question is a contract for the provision of services or for the sale of goods, or not any of the above kinds of contracts. Again, there is a comment about what is a contract for the supply of goods, and some references to relevant case law of the European Court of Justice. I will choose a contract for the sale of goods. And the next question is there an implied or express choice of court? Again, a comment about the requirements of the regulation about the form for the choice of court, and relevant case law of the Court of Justice. In our case, I will choose no. The next question is where is the domicile of the defendant, whether it is on the domicile of the defendant is in the territory of the European Union, or the exception is for the territory of Denmark, or other possible cases, Switzerland, Iceland, or Norway, or the domicile is in the territory of a third country. In this case, I will choose that the domicile is in the territory of the European Union. But again, I will stress on the comment here, which is important about the concept of domicile, that has a special meaning as per Article 62 and Article 63 of Regulation Brussels 1A. According to these articles, more precisely Article 63, paragraph 1, for legal persons, the domicile could be alternatively the statutory seat, the central administration of the legal person, or the principal place of business. So very important comment for in case the defendant is a legal person. And after having replied to these questions of the system, we see the first conclusion of the system based on the answers provided by us, the conclusion on jurisdiction. So in this case, the general jurisdiction rules apply, and the general jurisdiction rule, and also a special jurisdiction rule. The general jurisdiction rule is that the court of the country where the defendant has his or her domicile has jurisdiction, and because this is a contract for sale of goods, also a special jurisdiction rule is applicable, and the courts of the country where the goods have been or should have been delivered have jurisdiction. And at this step, we can produce a report of the case, which will include only the conclusion on jurisdiction, but I will go further. So, because we have chosen also to have decision support on the question of applicable law. So the next question is whether parties have chosen the applicable law. In our case, no. We say no. And then, is there a special case of a contract for the sale of goods by auction? No, in our case. So we have now also the conclusion about applicable law. The applicable law is the law of the country where the seller has his habitual residence. What is interesting in this specific case that usually the next button will not be active anymore after having also the conclusion on applicable law, but in this specific case it is active. Because the system would like also to ask the user, is the relationship in the scope of a multilateral international agreement which relates to the international sales of goods? No, in our case. And the final advice of the system is check whether there is a manifestly closer connection with the law of another country. And the comment is about what is the meaning of this expression, manifestly closer connection with the law of another country. If we return to the conclusion, 2 steps before that, we can produce a case report. In this case report, we have extraction of the questions to the user and his replies. This is in section about the case. Then we have the conclusion on jurisdiction, the legal basis for this conclusion, and then again about the case section with the questions concerning applicable law and the conclusion about the applicable law and the legal basis. This case report can be exported either in PDF or RTF format, file format. I will export it to PDF on my desktop. So this is the way how the report looks like. I will stop with the presentation with this module because the next presentation of Galileo Sartor is devoted also on the work of this module based on the case that was presented yesterday from Federica.
Thank you.
I will come back to the NTERLEX portal to present you briefly the next module, the Find Flow module. Okay, this is the home screen of this module. Let me turn back to the slides. Sorry. Okay. First, a few words about the content scope of this legal database. Actually, it's in the with this database we would like to cover almost all areas of European private international law. So in this module we have 4 data collections: international treaties, legislation, case law, and also expert materials. Maybe it is better again to show all these data collections live in the system. In international treaties, we have selection of such treaties which concern mainly civil and commercial matters. In legislation section, we have firstly all the relevant EU legal instruments in the field of judicial legislation, judicial cooperation, in civil and commercial matters. You see that there are more than 180. When we open this, we can see a list of all legal instruments, and on the left side there are filters with which we can narrow the results of the query if we make a search query, or if we open a folder from the initial screen. There are such filters which help us to narrow the results. For instance, I can choose here only regulations and receive only a list with the regulations in the area of European private international law. The first legal instrument is Brussels 1A regulation, then Rome 1, Rome 2, etc. But in section legislation, we have also a section devoted to national legislation in the area of private international law, to national legislation of 12 EU member states. You can see the member states as filters. Then in section case law, we have more than 9,000 judgments. Firstly of the European Court of Justice, more than 420 judgments in the area of private international law, and then more than 9,300 cases of national courts of all EU member states. And finally, in our database, we have many expert materials, such as research articles. These are open access documents that are free available on internet. We have done a selection of such articles, research articles, then of again free accessible books and studies in the field of private international law. There are many training materials and guidelines from various sources. For instance, a guide for the European small claims procedure, or for cross-border successions. When you open such a document, you can see the source of the information and a link to the source. You can see the language versions that are available, in this case in English, Italian, French, Bulgarian, German languages. Something which I recommend you are this collection of e-learning materials, actually links to such e-learning materials and other useful resources. Again, that are free, available on internet. For instance, this courses part 1 and part 2, e-learning courses on family law. They are prepared by the Academy of European Law. Okay, and for instance, an e-learning course on cross-border divorce and maintenance, again prepared by the Academy of European Law, ERA. It's an online e-learning course. and I recommend to you if you would like to gain more knowledge in this area. There are plenty of resources and also questionnaires with which you can check your knowledge after the self-training. And finally, in expert materials, we have the 12 national reports that were subject of the research activities under the NTERLEX project. For each of the 12 countries covered by the project, there is such a report on the national application of internet-related private international law. So here is the text of the report for Germany with links to the relevant EU and national legislation and links to the decisions of the German courts that have been summarized by NTERLEX experts. I strongly recommend you to visit to see these reports. Maybe especially interesting for you will be the report for Italian case law, which was presented yesterday by Esther Di Napoli. But the most important thing that I will like to show you are some functionalities of this legal database. And the most important is how to search for case law. So on the home screen, there is a list of the recent summarized cases in our database. As I said, we have more than 9,300 national cases of national courts in the area of private international law. And a great part of these cases are summarized, have a summary in English, and many of the cases also in French and German languages. When you open the national case law folder, you can see an easy way to access the case law of a particular country. From here, the filter jurisdiction gives you this opportunity. For instance, you can choose Italy. There are more than 700 cases. And when we open the cases, this filter, by the way, from here you can remove the selected filters, so you can return back to the previous selection, to the previous screen. And if you choose, if you see here the summary filter, there are some options to choose from. These are the different sources of case summaries. If you choose NTERLEX, this means that you will receive a list only of cases selected by the NTERLEX expert, which concern internet-related issues. All these cases are summarized by NTERLEX experts, but because this was a very important task, research task of the project, there is a special filter like a button from the beginning, from the home screen of the service. This button is called internet related PO cases. So in any situation, you can use this button to receive only cases that have been selected and summarized by NTERLEX experts, which concern internet related issues in the area of private international law. How we can search in this database? It's the way how we usually do in other search engines. We can type a search expression. I'm typing delict, for instance. You can see 333 cases, not only cases, but documents that contain this word. And if we like to search by phrase, by search expression, for instance, habitual residence, we have to put this expression in as a search expression. So in this way, you see more than 400 documents contain this expression. And in the list of the documents, I would like to show you how we can easily understand which case is of interest for us. There is for each case, we can see 2 lines of the summary, of the case summary. I will choose cases from Italy to show you this. Okay. And here is the summary. And if these 2 lines are not enough to understand whether this case is interesting for us, from this button here on the right corner of the judgment, we can have access to the full text of the judgment. So actually we don't need to open each judgment to see the summary. The summary is in English, as you see. But let's open one such judgment. And you will see that in this case, there are summary also in French, in Italian language, and in German language. So this is typical for one of the sources that we use the Jure database, which is the goal of this database is to provide summarized cases, landmark cases, so to say, and to provide case summaries in always in German, English, and French languages, and also in the language of the case, because this is an Italian case of the Supreme Court of Cassation of Italy. That's why there is also a summary in Italian language. One important thing about the languages in this database, we have the interface translated in available in 5 languages, not only in English, like the first module. The decision support module is available in English and also in Bulgarian, because a Bulgarian company was involved in its development. But for this module, we have tried to provide access in not only in English and Bulgarian, but also in Italian, German, and French languages. This is the language of the interface, but because we provide access to case law of all member states, of course, the full text of the decisions is available in the language of the case. But what I can recommend you, this is outside the scope of our service, but in many browsers you can use automated translation. I'm using Chrome browser, and I can ask the system to translate this judgment. We assume that this judgment may be of great interest for the user, and I will ask the Google Translate engine to translate it in Italian. So although the text of the case was in Bulgarian, we now have translation in Italian language. So this is a way how to understand the text, even if it is in another language that we cannot speak, but nevertheless to understand the reasoning part of the judgment. And I can assure you that in the recent years, the automated translation has been improved significantly. So indeed, you can understand even translations of legal texts. Another important issue that I would like to show you is how to search case law which refers to a particular provision. There are 2 ways. One way is to use advanced search from here, and then for case law to choose this option, referred act or provision, to select the regulation that is of interest for us. In this case, I'll select the Brussels 1A regulation, and then in the right box appear an option to choose which particular provision of the regulation is an interest for me. For instance, Article 7, paragraph 1, point B, letter B. I have chosen OK, and then the search button. So now the result is 21 documents. All are judgments. 7 from Germany, 4 from Bulgaria, 9 of the European Court of Justice, which refer to this provision. So this is a way how to search case law which refers to a particular provision, but the same option we can use we can use when browsing the text of regulation, a particular regulation. In our case, Brussels 1A regulation. Okay. We have a specific icon above the text of the provision, and again we have the same option, but from the text of the regulation, and of course the selection is only for particular article. Okay, for instance, Article 8, Paragraph 1, or Article 16, Paragraph 2, etc. Actually, quite easy way to select relevant case law when we check the text of the consult the text of the of a particular provision of the regulation. In the beginning of the regulation, we have metadata. It's the same like in the NTERLEX database. You know this database. And what is very convenient that here we have something which has been done by the legal services of the Court of Justice. It's information about the affected provisions of the regulation by interpretations of the Court of Justice. And for instance, we have here, you see Article 1, Paragraph 2, letter B, and we have we can consult the text of the regulation and the respective judgment of the Court of Justice. So this is another way how we can use this service. By the way, the text of the EU legal instruments, regulations, directives, etc., are all available in 5 languages: English, Italian. From here, you can change the language of the legal instrument: French, German, and Bulgarian. These are again the same languages as the languages of the interface of the system. So the legal instruments of the EU and the case law of the Court of Justice is available in these 5 languages in this free database. It's entirely free. You don't need to register or to log in. Even there are such buttons here, but they concern only some of the functions if you would like to use these functions. For instance, my documents or my searches. If you click here, you will receive this message. This feature is only available for registered users, but you don't need, if you don't like to use these options, to register. And the registration is simple, so again, it's the service is free. Registration does not mean that you have to pay for the service. And the last module, only a few minutes, because my presentation was too long. The last module, which can be accessed from the Intellects platform, is the training module. Module that requires obligatory registration. So you have to register to use it. Why? Because this is a training module which contains training content, and for using for subscribing for particular course and using it, it is needed registration, so that you can test your individual knowledge in this system. The system is based on the former LMS, which LMS mean learning management system. By the way, it was developed by Italian programmers, Italian developers, as a free software, as open source software. And we have used this software to adapt a module, a training module, which is can be used for the purposes of our project. In this module, we have with this module we first provide access to a short online course on EU private international law, which was developed by Professor Vasil Pandov, who is associate professor at Sofia University. This online course can be used first by law students, and second by legal professionals who are not specialized in the area of private international law, but would like to extend their knowledge, their skills also in this area of law. So this is an introductory course with 6 lessons. And it covers again Brussels 1 bis or 1A regulation, Rome 1 regulation, and Rome 2 regulation. I will open one of the lessons. Okay, here is the text of the lesson. The text of the lesson, again with links to the cited provisions of the regulations and to the case law of the Court of Justice. The links again refer to the legal database, to the find law module. So again, there is a connection between the 3 modules of the system in this way. And there is also a part called reading materials, which contains links to all relevant legislation, case law of the Court of Justice, and also to additional training materials that I showed you in the legal database module. And finally, there is you can after the self-training, after reading the text of the lesson and the additional materials, there is a test. I have made this test before, and that's why I will restart it. So there are questions and some answers. I will just put some answers without understanding the meaning of the question. just for show you how the test is completed. Then I submit my answers. Of course, I have not passed the exam, but I can see my answers. So with that font, it's written which of the answers are wrong, with blue font which are correct, etc. Okay, so this is the way how you can use this short online course. In the training module, we have also some categories, some courses which are actually were created for the needs of the test workshops that we have within the project. These courses actually contain the materials which were used in these workshops. The first transnational training, which was in Florence, then the testing workshop in Sofia, and here the materials for the testing workshops in Italy and Czech Republic. So you have access to all these materials also if you register for the training module. With this, I would like to finish my presentation. Once again, all the 3 modules are available from the Intellects platform and free of charge, so you can and I hope you will test these modules, maybe not in the weekend, but next week, and I hope you will like these modules.
Thank you, Christoph. Thank you, and thank you to the APIS unit. Are there any questions? Let's see if are there any questions. I don't think. If there are no questions, and after seeing how the platform is programming and what its components are, I will leave the floor, speak to Galileo Sartor and Federica Casarosa. They will show us how we can use the platform shown by Heathrow. Galileo is a researcher at the University of Bologna, while Federica is a part-time professor at the European University Institute. Through the use of the Intellects platform, we will try to solve the cases provided in the yesterday's meeting. So I will leave the word to them. I can't hear you. I don't know if it's my problem or not. I see you, Federica.
Yep, I'm waiting for Galileo because I will.
Okay.
I'm just
And Galileo.
Because I will just help Galileo, who was the mastermind behind the prologue of the prologue passport.
Galileo?
Yes.
You have the mic.
Is the microphone working?
Yes.
Okay. Okay, so Federica, you presented yesterday the two cases, and I would like to show a bit of a different approach from the one that Cristo showed us, because in this in our part of the project, we developed a rule base by translating the rules of the Brussels and Rome regulations into logical sentences that can be understood and worked on by an automated system by the computer. So I wanted to show a brief slideshow of what brought us here, and then I'll demonstrate this part of the platform in relation to the two cases. If that's screen. So I'll just briefly share the screen. Share that. Okay. So we started by analyzing what the current situation is, and that is the different ways of representing or modeling norms in computer readable code. So there are different systems. They can be XML-based system used to mark up documents, so to identify certain parts of the document, or reasoning tools that can be built on an ontology or on different rule bases. So we have a commentoso, for example. This is an open XML standard to represent legal documents. I won't go into details. Then we have different inferential engines for defeasible logic or for representing logic sentences, logic statements. We have some projects like the Spindle project that is built especially for drafting complex, for drafting certain sets of rules, mainly in the economic area. And then we have proprietary tools like Oracle Policy Automation, which is very easy to use. But we focused on a Prolog approach. So we used the programming language Prolog to document, to represent the legal norms, so we could tailor it to our needs. A brief example is Article 4.1, 4.1 of the Brussels regulation, which states that a person domiciled in a member state shall be sued in the court of that member state. And this is how we represent the rule. So we have to define a certain person, the defendant. We have to identify that person's domicile, and then we have to state that that domicile must be a member state. This is very simple. This is a very simple example, and we can complicate things by looking, for example, at Article 7.3, which states that a person can be sued in another member state, depending on where the criminal proceeding has happened, or whether the court has jurisdiction on civil proceedings. And this Article 7 is divided in many different parts. So we have to identify this fact to preserve a one-to-one relation between the legal text and the technical translation. To do this, we have to identify an ontology. So we have to we need a clear set of terms. We have to agree on the meaning of all these words and identify what the possible values are for each one of these terms. And in the NTERLEX case, the most important parts were the person, the concept of person, its nature, role, type, work, domicile, and so on. We have the claim. So what type of claim is it? What is the object of this claim? Because from this, we can have different solutions to the jurisdiction or applicable law issue. So we need to identify all these facts. Also for the contract, especially in the Rome regulation, we need to identify what type of contract it is, if it's an obligation or a contract, if it's an insurance contract, and so on. Now I'd like to show how this can work in a more user accessible way in relation to the two test cases. So Federica, if there's anything that you would like to say about the two cases.
My microphone. Okay, now can you hear me now? Yeah.
Federica?
Federica, we can't hear you.
Yeah, can you hear me now?
No, not now.
I have the microphone that works autonomously.
Your voice is very
Can you
low.
hear me now? Do you hear me now?
Yes,
Federica, va.
Okay, good. No, it was just I would like just to point out the work of Galileo regarding the translation into simple and mathematical items of what the Brussels regulation was formed. So what has been presented as the ontology is really how the elements that have been identified in each single characteristics, which is obviously the work of a lawyer when it reads the letter of the law, but at the same time translating it into a very precise and logical manner is an effort that was really hard for Galileo and for Giuseppe and also Francesca before for this work. And this is important because it allows us to understand each component of the rule that has to be taken into account and each element that can be used in terms of identifying which characteristic or which result can be identified at the end of this analysis. So as regards the cases, if you prefer, we can go through the factual circumstances and then Galileo can follow up with the analysis, or you can go on, Galileo, and introduce the elements into the prologue. I can just read back the document that was circulated and the cases that you find also in the web page that was made available by the Consiglio dell'Ordine. So there you will find not only the presentation that were available for these 2 days, but also the information regarding the cases. So if we want to go through the first cases, if you remember well, we have this Tizio, which is a Russian citizen domiciled in Italy. So according to the ontology provided by Galileo, we have already two elements that are different. So the citizenship and the domicile of the person. Accessing a website that is called alphaski.fr. So the website is managed by a company, Alpha, that is based in Germany and is specialized in the marketing of Normandy apples, which are highly appreciated by local consumer. So the website is in French. So the main, probably the main targeting customers are French citizens. And however, due to its popularity, the website also offers a home delivery service across Europe. Tizio, so our Russian citizen domiciled in Italy, becoming aware of the website thanks to a friend living in Normandy, decided to buy 50 crates of apple for himself and his family. A few days after the delivery, so we have a contract in this case, Tizio notes that the apples are altered by a virus that, in addition to having compromised the taste of apples, has the potential to cause serious health problems. I acknowledge that this case was not was drafted before the COVID appeared, so we are sorry for this kind of similarities, but unfortunately, this was based on a very simple case that was presented in one of the jurisdiction that were subject to our analysis. So, but it's funny enough that ironic enough that this is also related to what is happening now. So the fact that we have an infection that was caused by some food eating or some infection coming from food. So Galileo, please.
Yes. Okay, so I'll share the screen with the more user-friendly version of the rule base, so we can see if it works with these cases. Let's see. Okay, is the correct thing showing on screen? Let's see. Mm-hmm. Okay, so this is an example of the reasoning tool that we built, and here we can see we have a set of questions and answers, a bit like the decision support module that Cristo showed earlier. The main difference is that this is using taking the data from the answers and feeding them to the interpreter for the rule base. So this can be useful to, for example, can be very useful if we intend to add a new rule, or if we intend to modify an existing rule, in that we can easily see what changes would be possible in this with this new rule. Now we tried to find out what the important cases are in the first hypothetical case. So as we were saying, we have a defendant which is Alpha, and Alpha is domiciled in France. We can select add a city. Then we have the claimant. The claimant is Tizio. Tizio is has its domicile in Italy, Rome, and the object of the claim. We can either say that there is no object to the claim, and the result should be Article 4, the domicile of the defendant, But if we add further, if we go further and add more data, so the fact that this is related to a contract, that it is a consumer contract with the defendant alpha being the commercial entity and the claimant being the consumer acting, and the consumer is acting outside of his or her trade or profession. The activity, the defendant's activity. So in this, this is the defendant activity is in Italy. So this should tell us that the solution for this case, there are two possible solutions. One is France, Paris, and that comes from Article 18.1a of the Brussels regulation. Then we have Article 18.1b that gives us Italy, Rome as a solution. But we would it would be interesting to figure out why. Why did the system give us these answers? So what we can do is tell the system that we want a full solution. So now we have this screen, which still has, as we can see, two high-level solutions. So France, Paris, according to Article 18.1a, and Italy, Rome, according to Article 18.1b. But then for each one, we can follow the logic sequence that brought the program to give us that answer. So for example, we can see that the solution comes from Article 18.1a, and that the Brussels regulation does indeed apply because the claim matter is civil commercial, and there's no exception to this rule in the data that we gave the system. And we can see that the claim matter being civil commercial is a fact. So it is something that the system understood from the data that we gave it. Then we can see that there's part of the blocking jurisdiction, which Article 18.1a is part of. In particular, the system analyzed Section 4 of the Brussels regulation. And to apply Section 4, we need a person of type consumer. So we need a consumer. And the claim object needs to be a contract, related to a contract. And the contract needs to be a consumer contract. And these are all facts. Then there's Article 17c that actually tells us that we can apply this section because we have a consumer and a commercial entity. They're not the same person, and the commercial entity has his main activity in Italy for the with regard to this case. Also, the other person has a domicile in Italy. Going further again, we have Article 18.1a, because there is no jurisdiction according to Article 18.2, which would be an exception to this rule, according to how the article is written. Then we can see Article 18.1a is true because it needs to, let's say, to verify Article 18.1a, we need to have the person role of the defendant in a member state. So the person role is the person that is the defendant is Alpha. Alpha is domiciled in France. France is a member state. Therefore, this train of thought applies, and we have the solution Article 18.1a. The same thing happens for Article 18.1b. This can be complicated to visualize like this, but it can be helpful. And if we try to imagine it described in another way, we can add in our code the explanation for certain conclusions, and that explanation could be printed on screen here to always have the full explanation of what this reasoning tool has done. So not only the result, but why the answer to how did it get to that solution. So this is one of the.
Galileo, may I interrupt you just for a second?
Yes.
Because this is very relevant in terms of highlighting which is the objective of the Intellects deliverables. Because in terms of what is available from our project is the fact that we would like to provide legal practitioners for tools that help them to identify the solutions for the private international, for the internet-related cases, and in particular the private international law applicable to these cases. It is important to highlight that these are guidelines and information that are not 100% sure, meaning that given that we have a set of facts, these information can be justified. And these information that you provide and you clarify, we have each element, each factual element has been tested under the informatic conditions, so the condition that has been understood by the system, and helps the legal practitioner that may use this tool to understand why a set of elements has been used by the system. Obviously, if we change any of these factual circumstances, the result may be different and may be interpreted differently by the system. So it is important that this effort that you have made to make sure that there's not only just the single reply saying that France for Article 18, paragraph 1A of the Brussels 1 regulation, but it also provides why the system has decided in this direction rather than another direction. So it's just a matter to clarify that it's not just the information, the result, but also the reasoning that has been used by the system to achieve this result.
Yes, this is a very important thing to add. Also, I would like to point out that this explanation can help if we modify a rule, because the rule base can change as frequently as possible. We just need to update the new rule, update the old rule, or add a new one, or add a completely new legal source. So at the moment, this system, this graphical page only has access to the Brussels regulation, but we already have the Rome regulation that is mapped in its entirety and can be added to a system similar to this. But we can also add the GDPR or national laws. We can add any type of rule we want, and as long as we write them according to if we write the rules according to a dictionary and a syntax that we agree upon, then we don't even need to have. Then different people can be responsible for adding different rule bases. For example, every European country could have its own rule base that all feeds into one system. And so I think it can be very useful to also, again, to test what happens or what could happen in different cases. Now I'd like to show, if it works, what happens if we change just a few details. They are very important details, but if we swap the role of the defendant, so if we say that the defendant is the commercial entity, let's see, the other way around. If we say that the defendant is a consumer and the claimant is a commercial entity, we should have a different solution. And personal activity in Germany, let's see. It's not working. Let's see. This is a problem with showing things that have recently been added. Let's see.
Now you just put two consumers. You have the defendant. Oh,
no, it should be fine, but it's the consumer, the defendant's activity. Let's see. No, I'm forgetting something. I'm not the legal expert here, so no. But it should say, if I query it without the graphical interface, it should have article 18,2 instead of 18.1, and I must be missing something in this user interface. But the idea, anyway, is that we can have different. We can see what changed, and we can then compare different solutions. We can compare what we imagine the solution to be to the result of this reasoner, of this explanation system. So this was the first of the two examples. We can try to see if we're better off with the second example. So in the second example, the second example was a case based on tort or delict. So we had the defendant, which was the All News. I think this was the correct defendant. Anyway, he was domiciled in Germany. Correct me if I'm wrong. I'm going off of. And then we have the claimant. The claimant is Mario, and Mario has his domicile in Rome. The subject of the claim this time is tort delict, with the harmful event taking place in Italy. So we should see that we have Article 7.2 that says that the jurisdiction is assigned by Article 7.2 to an Italian court. And we also have Article 4, which is the defendant's domicile, that says that the jurisdiction is assigned to Berlin, to the court of Berlin. If we, again, ask the system to have a full solution, we can see the explanation for both Article 4 as well as Article 7.2. So we can follow the train of thought, we can follow the logical sequence that brought us to these conclusions. And this is this can be useful also to identify possible issues in relation to national legislation or other legal sources. So this is I think can be useful also in identifying what the useful facts are, because it could be that I'm inserting in the reasoning tool more facts than the ones that are necessary. So I could also see which facts do I need to solve this issue. What do I need to consider? What do I what possibilities do I have if I can change a certain fact? So on top of this, we can go further and add different ways of reasoning. We could also add a system that can give us the two solutions that it can reach with the facts we gave him, and also the possible solutions that could be added if we were to, for instance, add the fact that our client or the person involved has also a different residence or a different habitual residence. It may be that we either we forgot to add a fact, or even that the law changed. So the possibility of having the easily visualizing what changes in these laws in time can be very useful. So I think that with this this part of the presentation is over. If there are any
Galileo, do you mind if
yes?
Again, interrupt you? But one of the important items of this reasoning tool is the fact that it will be also introduced within the Intellects Platform. So at the moment, this is a tool that is yet to be addressed, to make available. So at the moment, the practitioners that would like to use our tools will rely on the information that was and the tools that were presented by Risto before in the previous presentation. But this will also be available and integrated in the Intellects Platform. And it will also help because one of the, for instance, problems that may emerge in the first case is one of the problems that are the definition of consumer that is provided under private international law, that is different from, or at least is stricter than the one that is provided generally in other EU law instruments. So we have problem of interpretation that may emerge in the analysis of the factual circumstances. But the issue of using this reasoning tool, it's still helpful because will allow the person using the tool to identify easily what are the elements. And as you were mentioning earlier, the fact that changing small circumstances or elements of the elements that were available in the case but can be interpreted differently may clearly be changed, easily changed, and then you can immediately see what it would be the different solution for the case in terms of jurisdiction in this case, but also, as you were mentioning, also law applicable when we will be able to add those mapping to this tool.
Yes, regarding this, the plan is to have to connect this rule base to the existing Intellects platform, and something that could be useful is to keep the explanation that the explanation that was given by experts, and then to identify if this is true also for the rule base. This can be useful to see if a certain interpretation of the law has changed, or if it is no longer valid, or any of these different interactions between the actual text of the law and the interpretation. Also, in the rule base itself, it could be possible to not only try to be as close as possible to the legal source, which is what we have done so far, but also to identify different common interpretations and add those as well into the knowledge base, with the note that they are only they are only interpretations, so they might have less value than the legal text, but they can surely help in understanding the legal source, and can also help in explaining those cases where it is difficult to identify precisely what the legal source is talking about. So there could be vague concepts or certain details that the system, that the law gives for granted, that can be explained by an expert of the field. And so one possibility is, as I said, to add a sort of verification step, a sort of a check that says that the solution of the expert is in fact true according to the rule base. And this can also help both ways, because we're all human, and the rule base is only correct and only works properly if it is used and if it is tested. Because again, we translated most of it. We translated most of the Brussels regulation and the Rome 1 and 2 regulation, but the eye of an expert is always welcome. So I think it's a good solution that can also evolve over time. So I think it could be very interesting to have the two systems working together, and with the possibility of adding more functionality to both of them in time. Let's see. Okay. So I think that this is a good point in this presentation to thank Cristo for the help that he's given us in this work. We've used the documents available on the Intellects Platform a lot in trying to decipher parts of these regulations. Also, it would be it is very important to be able to connect to link a certain solution of the system, of our system as well, to the different case law and detail available on the Intellects platform.
Okay, I don't know if Federica wants to add other thing. Federica, your volume is very low for me. I don't know why, because I have the volume at the maximum possible. Let's try to.
Can you hear me now?
Yes,
Well, don't
it's
want
better.
to add anything because I was having my microphone and I was speaking very low. No, I don't have anything to add. I thank Galileo for this very useful presentation, for the fact that he had the opportunity to translate into a different, more structural language the laws that usually have loopholes and ambiguities that sometimes have difficulties in terms of interpretation.
So I will try to ask to Andrea if there are any questions.
No question at all. No question at all.
Okay, so for the concluding remarks, I will ask to Alessandro if he wants to say anything about these today's events.
Okay, yes, I'm very happy for the result and the goal reached by this training transnational event. I'm very sorry that pandemic emergency could not has to be physically in our historical city of Rome, but I'm very happy for the result we reached. And thanks a lot to you, to Federica, Suristo, and Galileo for today's exposition of their work.
So, if it's all, we can conclude this. Tell me, Federica, we have to wait. Luigi?
No, unfortunately, I would like to add and to greet you also from the part of Luigi. I was well, okay. I was supposed to have there was supposed to have a very short presentation on some of the potential impact of private international law over transnational collective remedies, but you will have the presentation available in the materials. Anyhow, I would like to thank you all for the presentation, for the wonderful work done so far, in particular to the Consiglio degli Avvocati di Roma for the really amazing organization of this event and for the availability to reach so many practitioners in this very short time, and the possibility to present this tool that will be available. And one of the added value of this project is the fact that we will have the possibility, at least for other couple of weeks, to add additional judgments and decisions if possible. So if you think that you have cases that could be interesting also in terms of testing our system, please feel free to contact us in terms of suggestion for cases that may be used to test and to improve the number of judgments that are available at national level. As you have seen yesterday, we have a limited number of cases because, unfortunately, this is a topic that is still yet to be developed by the jurisprudence. But we are looking forward to have your suggestions and your cases. So feel free to contact us on this.
Many thanks to you all. Let me send a regard in Italian to all the Italian lawyers right now in the YouTube channel. Un caro saluto a tutti i colleghi che ci seguono dal canale YouTube per questo evento FAD. Ringrazio ancora una volta Cristo, Federica, Francesco, Galileo, il consigliere tesoriere Alessandro Graziani. Le registrazioni saranno sempre a vostra disposizione tramite la piattaforma YouTube e le registrazioni stesse verranno poste anche nell'area pubblica. Mandate i documenti così come vi ha indicato la professoressa Cesarosa e noi saremo in grado di trasmetterli in tempo reale sostanzialmente. E davvero questo è tutto anche per quanto mi riguarda. Un caro saluto a tutti voi, buon fine settimana e niente, ci risentiamo alla prossima di nuovo, arrivederci.